Today, I will present an overview of the IP mediation as it takes place at the Boards of Appeal of the EUIPO. So my presentation will be divided in three parts. In the first part, we will go through the alternative dispute resolution service of the Boards of Appeal and the different mediation techniques that our service offers to the users of proceedings before the EUIPO. In the second part, we will go through the actual process of mediation as it is applied by the EUIPO mediators here at the Boards of Appeal, and also the phases of the mediation discussions. And finally, in the last part, I will share with you some useful resources on mediation and on our service that you can easily find online. So let us start with the presentation of our service, the ADRS, which is part, as mentioned, of the Boards of Appeal of EUIPO, and the ADR techniques, including, of course, mediation that are offered to the users. The EUIPO Boards of Appeal is a modern IP dispute resolution hub. Our priority is to offer effective resolution of IP disputes to our users. From this perspective, first of all, we support, of course, the owners of the IP rights, offering the classical administrative approach to conflict between parties through taking decisions on the appeals received. Secondly, we are also offering a full mediation toolkit through our service, the BoA IDR service, to businesses and individuals in order to provide with alternative options that do not involve the risks of solving a dispute through the traditional litigation channel. For businesses and their legal representatives, as well as for any other institution that is assisting business owners, it is always valuable to know what are the available what the available options are, what effective dispute resolution mechanisms are at their disposals, and how and when to use these options. So within the context of the EUIPO Boards of Appeal, we offer, as mentioned, a full mediation toolkit to businesses and individuals. In the wake of COVID-19 crisis, all these services started and continue to be offered online in order to facilitate the smoothness of the procedures and to avoid any unnecessary traveling. All proceedings, therefore, are conducted remotely through MS Teams or Zoom, or even by phone if this is preferred by the parties. Moreover, as already mentioned, in the proceedings before the office, no additional charges apply. So what are these services offered by the EUIPO in the mediation toolkits? So the services are mediation, of course, conciliation, expert determination, and a special service for SMEs, which is called Effective Dispute Resolution Service. These services are available to all parties involved in inter-partes proceedings before the Boards of Appeal, and but I will come back again to that to explain the different processes on which we could use this alternative channel of mediation. So turning now to the users of the alternative dispute resolution services, who can use these services? In this context, please note that the proceedings must always be, as I already mentioned, inter partes, which means that they should involve at least two parties in conflict. So this means that, of course, the office cannot be considered as a party. So we're talking about two private parties without counting the office as a party in a conflict. So if we drill down to the specific proceedings, when there is an appeal before the Boards of Appeal of the EUIPO, all users can make use of the alternative dispute resolution services, including, of course, SMEs. As you already probably are aware, the Boards of Appeal is the second instance of the office. this possibility of using ADR and mediation is going to be extended through the mediation center that will start, it's scheduled to start at the beginning of 2023, but for the moment, this possibility of using ADR is only limited to users before where an appeal there is before the boards of appeal. Other than the inter partes before the appeal proceedings in the boards of appeal, only SMEs for the moment, mainly from the European Union, can use through the effective dispute resolution service these ADR services. So this special service is offered in first instance proceedings before the office for SMEs that are involved in opposition, first of all, to an EU trademark, after the end of the cooling off period, and only if the SME is an unrepresented SME, in cancellation proceedings of an EU trademark, and for the design invalidities proceeding, for the registered design invalidities proceedings, and of course, for appeals, as mentioned, for all users. So we see that for SMEs, there's still possibility being in the first instance to use the ADR options. Let me now give you a brief overview of the techniques of the mediation toolkit and the specific features and advantages of each technique. So mediation is one of the most used alternative dispute resolution mechanisms. The conflict resolution process is designed to lead to a mutually beneficial compromise. And for this, it involves distinct phases that I will analyze further in my presentation. The mediator will guide the parties in the dispute through the process in order to try and reach an amicable settlement of their differences. This can cover the conflict, of course, that is pending before the EUIPO, but it can be extended also and cover all other conflicts that the party may have, either in the EU or internationally. In mediation, the mediator does not propose a solution on the substance. This is important to keep in mind. He or she will attempt to identify the common grounds and business interests of the parties that may be explored in order to settle the dispute. On the contrary, in the case of conciliation, the conciliator proactively suggests possible solutions to the dispute. These proposals, of course, the proposals of the conciliator, will be discussed, negotiated, and fine-tuned with the parties, who remain, of course, free to accept or decline the proposed solution by the conciliator. Another type of ADR is the expert determination. So the expert determination is an option that the parties may have to ask for the opinion of an expert that will help them reach a settlement agreement. So the parties can jointly and voluntarily decide to opt for expert determination. And in that case, an expert will be appointed by the parties to give a non-binding or sometimes binding, if the parties decide so, opinion on a specific aspect of their conflict. Normally, this concerns a specific technical or legal issue on which the parties have a difficulty to agree upon. So the expert determination, it is important to know that it happens in the context of an ongoing ADR process, such as mediation. So we have a mediation that is ongoing. There is an obstacle on which parties cannot agree upon, and to overcome this obstacle, they ask for the opinion of the expert. And this will help, of course, the parties clear their path towards reaching a settlement agreement. We can refer to this combination of ADR processes, for example, the combination of mediation with expert determination as hybrid ADR process, a hybrid ADR process, which is of course perfectly possible, and to have it also in practice. And sometimes it's very useful because we can use expert determination in order to overcome a blockage that could be created in the context of mediation. So let me now briefly come back to this special service I have mentioned that is provided to SMEs, called Effective Dispute Resolution Service, and its offer since the 1st of July 2020. So this is a pilot initiative that is run in conjunction with the EUIPO SME program. For the proceedings that we talked about earlier, for the opposition, cancellation, the registered design invalidity, and for appeals, an SME can ask the EUIPO to designate an EDR case handler. And the role of EDR case handler is to guide the SME through the amicable resolution possibilities that are available in the EUIPO. So the objective here of this special service is to help the SME to find the most time and cost-effective process and to avoid complex litigation proceedings, which of course are draining resources and acting as obstacles to small businesses. Again, this process, as all ADR processes before the Boards of Appeal, is completely remote and takes place online. And of course, also in that case, no additional charges have to be paid. So that was the overview of the services that offer to our users in the Boards of Appeal of EUIPO. And I will now go to the second part of my presentation, which is to go through the procedural steps and the methodology applied in case of a mediation process before the EUIPO. So, of course, this process is established and detailed in the Boards of Appeal Presidium decisions that contain the framework for mediation before the EUIPO. So the mediation process is triggered by a request by either one or both parties by the rapporteur of the case. So the rapporteur is the member of the Boards of Appeal to which a specific case has been assigned. So by this invitation, either by the parties or by the rapporteur, there is a suggestion to use mediation or another ADR. If both parties agree to this suggestion, then the parties should proceed to selecting the mediator or the co-mediator of their choice. Then the actual mediation process starts, and this is divided into two parts. First, we have the part of the preparation phase, where we have the pre-mediation planning and the contacts of the mediator with the parties, the first contacts of the mediator with the parties. And then, of course, the mediation day, which starts with an opening session where the mediator and both parties participate. Bilateral meetings of the mediator only with each of the parties separately, and also joint sessions, again, with the mediator with both parties. And finally, of course, the concluding phase where the settlement agreement is drafted. So the first phase starts with the request by the parties. As mentioned, this can be either a unilateral request or a joint request. So one of the parties practically asks for mediation, and then the request is transmitted to the other party. If the proposal is accepted by the other party, the mediation process is triggered. If the proposal is declined, of course, the ordinary appeal proceedings continue as scheduled. In case we have a joint request, so in case both parties already have agreed and they send a request to our service to start mediation, in that case, they also are requested to define a mediator, and the proceedings of the appeal proceedings at the EUIPO are directly suspended. As already mentioned, it may be the rapporteur that the person that handles internally the case that suggests the use of ADR to the parties. In that case, of course, there is a communication that is sent to the parties proposing a mediation. And if the parties accept, if both parties accept, the process continues and the mediation is triggered and the appeal is suspended. If, of course, is declined by one or both parties, the ordinary appeal proceedings continue as scheduled. So the preparation phase that mentioned is finishes with the choice of mediator from the list of EUIPO EUIPO mediators. So the list and the CVs can be found on the EUIPO website. If there is a problem and the parties cannot agree on choosing the mediator, of course, our service can help in the selection. The most common criteria that are used by the parties to choose amongst the mediators is, of course, the language that is spoken by the mediator, the experience that the mediator has, and also the mediator's availability time-wise. It is also possible to opt for co-mediators, so to choose two EUIPO mediators for this specific case. This is an option that is used mostly in complex cases. So once the choice is made, the parties need to send an official communication to EUIPO on the choice of the mediator or the co-mediator, saying that we have chosen this person to handle our case. So this is the list of our mediation in the website. As mentioned, in the website, you can also find the CVs in order to see the experience of each mediator. So also the CVs contain information about the spoken languages of each mediator. So this is very helpful for any party wishing to appoint a mediator with the most relevant background and experience to the field of disputes that concerns the specific file, and of course, where possible, to choose a mediator who will lead the discussions in the party's mother tongue. So a mediator who is native speaker also in the party's mother tongue. So the actual mediation process starts, as we mentioned, with the preparation. Then we have the opening session. Then we go to the phase of exploration, where the mediator explores further the interests of the parties behind the legal position of the parties. And of course, then we go to the bargaining phase, which is the phase when the first offers start to be formulated between the parties, and then if everything goes well, to the concluding phase of the mediation process. We will go through these phases in a bit more detail. So in the pre-mediation planning, so the mediator, as soon as he is appointed or she is appointed by the parties, they send a letter of introduction. So this letter of introduction, they request the selection of the mediation venue by the parties. Of course, this last month, because of COVID, most mediations take place online, and it seems that online mediation is here to stay. They ask for a range of the available dates for the parties. They require all the attendees from both parties to be identified because they need to sign, of course, confidentiality agreements. And then an important point is that the mediator reminds to the parties that the business decision takers should be there. So the persons the person present should have the authority to settle the case. For example, a CEO of the company, it's recommended that the CEO of the company participates, or that he or she has delegated somebody else and has given authority to settle, because at the end of the mediation day, if both parties agree, we should be able to advance to a settlement. So it's very important that the people present, they have authority to settle the case. So of course, the mediator attaches the mediation agreement, not the settlement agreement, the mediation agreement, meaning the agreement by signing which the parties agree to enter into mediation. And of course, part of this agreement is the confidentiality annex. And of course, sets the time frame for receiving from the mediator, sets the time frame for receiving from the parties the summary of the case. Then the mediator calls the parties individually, or one or several times for this, what we call preliminary meetings. It's the meetings that are organized before the mediation day. And of course, this is to clarify issues, to respond to any practical questions, to explain how the mediation process will unfold, and already to explore which are the important points for the parties in this specific case. So to check if there is history of previous negotiation, for example, including offers that have been already made, or even to explore if the parties have already some ideas how they see the settlement of the case. It is important to stress that the mediator already starts from this phase to establish what we call a rapport with the parties and their representatives by giving clear answers and being transparent regarding the mediation process. And also by doing this, of course, the objective is to develop trust, not only to him or to her, to the mediator role, but also trust to the overall process of mediation. So in the actual mediation day, we start with the initial joint session where the parties and the representatives meet for the first time. So the mediator starts they meet all together for the first time. So the mediator starts by explaining his or her role, and the role, of course, of the parties and the lawyers. And of course, the mediator sets the ground rules of the process. So it is important to remember that the role of the mediator is that of the facilitator of the process. So the mediator is the process manager of the conversations that will take place. His role or her role is not to make decisions. It's the parties that will make the decisions. It's the parties that decide on the outcome of the mediation. So the ground rules, of course, are explained by the mediator. The cornerstone of the mediation process is confidentiality. So first and foremost, it is necessary to reassure the parties on the confidential nature of the mediation process. Of course, the process and the discussions that take place in the mediation are without prejudice. So meaning that the summaries of the case, documentations, and contents of the mediation cannot be used in evidence in any later litigation. Furthermore, another important principle is that nothing is binding until the settlement is signed. So this is important in the sense that because it gives the parties more freedom to explore different alternatives without feeling that they are committing to something specific from the start. So then, as mentioned, the mediation is is a process that is handled by the mediator, but it's a flexible process. So it's a process that does not have strict procedural rules. So it's the mediator who will decide if a bilateral meeting with one of the parties is necessary, or it's necessary to proceed, for example, with a joint meeting with both parties. These are decisions that are taken by the mediator. On the contrary, the outcome of the agreement is decided, as already mentioned, by the parties. So the parties are the decision makers. The last ground rule is the confirmation of the authority to settle. So the mediator confirms, asks the parties to confirm, that indeed they participating in this mediation having authority to settle in case the discussions reach an agreement. So after these explanations from the mediators, the parties proceed with their opening statement. It will ideally have been agreed with the parties in advance who will go first, and which member or members of the team will deliver these opening statements and initial comments. Then, once this is finished, the mediator draws up a list of issues with the parties that are in order to encourage constructive dialogue, and draws up the list of the issues that the parties consider that need to be solved in order to reach a settlement. This is what we call the working agenda. Then we move up to the exploration phase, and the discussions in the substance of the dispute start. The exploration will encompass several meetings where the mediator will alternate individual private sessions with one of the parties, or possible intermittent joint sessions. So the use of individual and joint sessions and the right moment to introduce them is fundamental to the whole mediation process, because it's strategic. So normally we'll start this phase, the exploration phase, with individual sessions. And then if the mediator considers that it's beneficial, we could continue to joint sessions with both parties. So it is extremely important for this phase to continue working on building trust between the mediator and the parties, and also trust in the process, on the process itself, and also handling the emotions that will come up during the discussion is very necessary skill and important skill for the mediator. So the mission of the mediator is, of course, the fact-finding from the parties, where the use of simple open-ended questions to parties, so give enough space to the parties to express their opinion, is, of course, a very powerful tool that needs to be put in use by the mediator. The objective here is to identify interests behind the strict legal positions of the parties, and also to shift the focus from the old disputes, the past differences, to discover future and to explore future possible solutions. Finally, the mediator will try to steer the process from the exploration to the next phase, which is the bargaining phase. The bargaining phase, of course, starts when the parties are ready, the discussions are mature enough to go from the exploring interests and possible solutions to start talking about numbers. And this is the phase where the mediator starts conveying concrete offers from one party to the other. In case the agreement is reached, the key elements to cover in this phase, the last phase of drafting the settlement agreement, are the following. So if we reach an agreement, the agreement should satisfy the parties and be workable. So it should cover all points. It should reflect, of course, what has been discussed, and should cover everything that has been agreed. It is important to say that the outcome, of course, is decided by the parties, and the legal aspects should be verified by the lawyers of the parties that are present. The role of the mediator is that to check that all the key points that have been discussed are included in the agreement, and of course that the relevant clauses that the settlement agreement should contain are also there, have been included in the settlement agreement. For example, the applicable law and competent jurisdiction clause, or the confidentiality clause, or the legal the clause relevant to the legal costs, that they're all there and covered by the settlement agreement. However, it is an important point is that the mediator is not liable for the outcome of the discussions, because of course the parties decide on the outcome. And also the mediator is not liable for the legality and the enforcement of the settlement agreement. As we said, the legal aspects of the settlement should be verified by the lawyers. In case there is no agreement, or in case there is no agreement, if no settlement is reached, it is recommended that the parties agree on follow-up actions. In that case, it's the valuable progress that can be made in the discussions could be very useful, and the negotiations could continue on this basis to cover also the outstanding matters. So, or the parties, for example, may decide to move to use another ADR to go to conciliation, or resolve this pending issue through an expert determination process. So even if in the rare case where settlement is not found, already the process that has been made is very, very valuable. So the formal steps that are taken by the EUIPO after the end of the mediation are the following. First of all, to protect confidentiality, and we are very strict on that, the mediator should destroy all the relevant documentation. At the same time, the ADR service sends out a satisfaction questionnaire to the parties regarding both the procedural and the substantial part of the mediation. In case of settlement, the registry, or the Boards of Appeal registry, of course, after request of the parties, will resume the appeal proceedings, and the parties could withdraw their appeal. And in case of no settlements, if the parties wish so, they request formally the resuming of the appeal proceedings before the EUIPO. And let us now go through the last part of this presentation, the overview of the available resources on mediation and other ADR techniques offered by the Boards of Appeal of EUIPO. So these resources may be easily accessible online and can be very useful to whomever might be interested in knowing more about the services we offer. So the office's website is also our specific, the ADR specific web page, are rich and dynamic enough to provide to any person interested with useful information. We also have detailed explanations about each of our services provided, and of course the relevant legal documentation. You can also find on the website request templates if you would like to request an ADR. So the template is also online, and some practical information about, in general, the steps, the processes, and the actors of each of the ADR services offered. Another very useful document that you can find also online, and you can download it, is the model ADR contractual clauses document. So this document contains model contractual clauses that can be used in commercial contracts in connection to IP rights. So the parties can agree to use one of these contractual clauses. So in a case of a future dispute, they could first use an ADR process, and if this doesn't work, then to go to traditional litigation. So lastly, in our website, you can also find and download our brochures. One brochure explains the services offered by the ADR service, and the other brochure explains the mediation process as I described it today in our presentation. So this brings me to the end of my presentation. I would like to thank you for more attention.